Mr. Hodges, Ms. Arlana Johnson,
Here.
Ms. Carol Johnson, Ms. Lee, Ms. Massey, Ms. McEachran,
Here.
Ms. Morris, Mr. Stokes, Stokes, Ms. Washington, and Ms. Stacy Williams. Okay, anybody come in after I called roll?
I did.
Barnes?
Mr. Cruz, I got held up. Some lady was sitting at the red light up here.
Did you get Morris?
I did. I figure we might have to be a little accommodating on class roll because shutting down the interstate. The exit I was supposed to take, the one that they've been advertising for 2 months was going to be open, was closed.
Closed for funeral procession today.
Uh-oh. Caraway Boulevard's supposed to be open.
They're doing funeral procession for the police officer from Trustful to Birmingham this morning. So it's going to be,
But not till 9:30.
yeah, it's going to be a mess. Yes.
All right, any questions about last week? Again, this week looks like it may be quick. There's not as many cases, but there's still the same number of pages. So if we get started early, we can leave early. Ms. Benson, you want to take Bala versus Gambro?
Yeah, I'll do.
Bala served as Gambro's in-house counsel and the manager of regulatory affairs.
Can y'all hear back there?
Can I hear? After learning that Gambro's Germany company was shipping dialyzers that did not comply with the FDA regulations, Bala advised Gambro's president to reject the shipment. The president refused, and he ended up firing Bala after Bala reported the defective shipment to the FDA, which began an investigation into Gambro's practices. Bala later filed a retaliatory discharge action against Gambro. The trial court granted motion for summary judgment because Bala's decision involved applying law to fact and that his duties led to his discharge, and the defendant had the absolute right to discharge him. The appellate division remanded that holding and stated that Bala's right to sue for retaliatory discharge depended on facts to be determined by a trial.
Okay, you missed the Hobson's choice in there.
I missed the what?
Hobson's choice. Did you not see that? Right on the bottom of 601. Anybody know what a Hobson's choice is?
Not good decision.
Situation. I couldn't find the history on it.
Really? All you have to do is hit the magical Google and it tells you.
Crap choice.
Hobson was a guy that rented out horses. And whenever somebody came to him and wanted to rent a horse, he said, take the horse nearest to the stall door or don't take any at all. So what was the choice? You had to take the one closest to the door because if you didn't, you weren't going to get one at all. So Hobson's choice really isn't a choice, is it?
It sounds good.
It does sound good. It sounds like marketing. They make it sound like you really get something and then you turn out not getting anything at all. No choice. His Hobson's choice was report the violation to the FDA and lose his job or lose his license. Lose his license to practice because it violates the rules of professional conduct. That's important because you got to know one important thing out of this case. What is the rule of law in this case?
That,
The lawyer gets screwed. Is that not the rule of law in this case? The lawyer does not have an action for retaliatory discharge because a client always has the right to fire a lawyer, even if your client is your employer. So that's the rule of law you take out of this, is that the lawyer has been singled out as not having the right of retaliatory discharge because the client always maintains the right to fire a lawyer. Does that make sense? To anybody, does that make sense? Really? Why would you single out lawyers as the only people who can't have a retaliatory discharge?
Because they have the means to retaliate every time.
Well, the rationale said that in order to promote the public confidence in disclosing fully everything to your lawyer and the public ability to fire your lawyer at any time, that those need to be preserved. Therefore, lawyers don't have the right to retaliatory discharge.
I didn't understand that they really didn't take into consideration he had other duties, like he had another role.
That's what I was thinking too.
they did say something about it, but they said
House
it.
counsel.
Yeah, but it was.
But he wasn't acting as a lawyer in that. He was acting as a marketing manager.
He used knowledge he's learned as counsel.
It was a privileged communication.
But what about the public safety?
He was bound by ethics to report it because his client was breaking the law.
But then he wasn't acting as an attorney.
Did you read the rule in there that says if it is likely to cause serious injury or death, lawyers have to report it? Now, let's talk a hypothetical. What if you're representing a criminal defense client on a charge of murder? And your client comes to you and says, I don't like that witness, I'm going to go kill him so he can't testify against me. What are your duties?
You have to report it.
Don't you have to inform the witness? Like you have to.
Okay, now, your client tells you this, right? Is that a privileged communication between a client and a lawyer?
No.
Absolutely privileged. It's between a client and a lawyer.
But he told you he was about to commit another crime. Doesn't that get rid of the privilege?
You resign as his lawyer.
It's an exception to, it's called an exception to the privilege. You have to report serious injury or death. You have a duty to disclose that. You have a duty to disclose if your client is going to commit a serious injury or death to another person. Now, do you have a duty to report it if he says, I'm just going to go out and rough him up a little bit? Not serious injury, just rough him up. Not a serious injury.
Well, it's so bright
That
on
you
the body
should.
of the person.
Do you have a duty to disclose it if it's not going to be a serious injury?
Well, how can you know if it's going to be serious?
Your client says they're just going to rough him up a little bit.
Well, I can't tell him to go commit a crime.
You can't tell him to commit a crime, and you can't help him commit the crime. All right, let's take an easier one. What if your client says, I want you to put me up on the stand so I can tell my lie?
I mean, it writes you not guilty yourself.
You want to know the best thing about this case? It introduces you to the fact that you're going to have to take an ethics class. And it's a lot of hard rules in ethics. And this is just one example that it was, the product was actually going to cause serious injury or death to individuals if they sold it as a non-compliant piece of equipment that the FDA regulates. So the lawyer had a duty to report it in that case. You'll find out a whole bunch of other duties lawyers have when you take your ethics class. Suffice it to say, for this exam, the lawyer does not have a cause of action for retaliatory discharge. Even though it's a Hobson's choice, either lose your license or lose your job. And what happens when you lose your license? You lose your job, right? Because your job as in-house counsel's over if you lose your license. Or you get fired if you report them, and that's, at least you have your license, you can go work somewhere else.
Like,
This
the
still
court said
today,
something.
that's still an effective act, even after there's some lower laws and stuff, that's still.
I believe that's still good law.
How would these hire attorneys and put them in positions like this with that intent, knowing
Oh, yeah.
full well that they can't, I mean, is that a thought out plan?
Yeah, because if they-
for employers?
I have one answer to that. One word answer. Health South? Or how about Giuliani? You know, they put their attorneys in awkward positions all the time. All right. It says all attorneys know or should know in their professional career that at certain times they will have to forego economic gains in order to protect the integrity of the legal profession. Right at the third to last paragraph on 602 of the opinion. 2 full paragraphs and a sentence above the notes. I guess they tell you got to be prepared to fall on the sword for the sake of the profession. Over on 6-on-3, granted the priest-like license to receive the most intimate and damning disclosures of the client, granted the sanctity of the professional privilege, and granted the uniquely influential position attorneys occupy in our society. I can't believe they put priest-like and attorneys in the same sentence. They're both the privileges, though, right? You'll get those privileges in evidence, and if you're in my civil procedure class, you'll get them in civil procedure as well. All right, look down further on 603, next to last paragraph above number 5, the collateral source rule. Are y'all in torts?
Yes.
Have y'all learned about collateral source rule yet? Oh, let me tell you the joys of collateral source rule. It's in the paragraph says, consider also the issue raised in Coral v. Huron Castings. The collateral source rule is in quotes. The collateral source rule is this. If you have somebody else pay benefits on your behalf, the person who injured you is entitled to receive an offset for that amount. Okay. Let's say you're involved in a car wreck, and you go to the hospital and you use your Blue Cross card. Everybody with me? The person who ran into you gets the benefit of the fact that Blue Cross paid for certain of your medical treatment rather than you yourself. Now, who pays for Blue Cross? You do, but who gets the benefit of it? They do. And it's collateral source because it comes from somebody other than the tortfeasor. Well, they use that also in context of contracts.
No, it just make their damages to be less.
It makes their damages to be less. Let me give you an example. MRIs routinely run $1,800, right? But my insurance company only pays $100 for it. So if I get involved in a rear-end collision and have to go get an MRI, I've got $1,800 worth of damages, right?
But don't the hospital ask you specifically if this is a if you got hurt in the workplace or if it's somebody else's fault? So
That's workers' comp,
They have to be paid back.
If they ask me before if I was in a car wreck in which somebody else is at fault.
and that's so they can create a hospital lien against your recovery.
Really? I thought it was so they could go after the other person's.
No, it's so that they can go to them and say, we got to be paid before you do. It's a hospital lien.
Oh. That's what personal injury lawyers are so popular. They work this stuff out, right?
They do work it out. So let me get back to my example. You're rear-ended. You have to get an MRI. Now you've got $1,800 worth of damage, right? And if normal pain and suffering is going to be about 3 times your pain of your medicals, now you've got about $5,400 worth of pain and suffering and $1,800 medical. So you're somewhere around $7,000, right? $7,000 would be a pretty fair recovery for that. Just for that. Now take insurance has paid $100. So now your damages aren't $1,800, they're $100. Your 3 times pain and suffering is going to be another $300. So you turn $7,000 into $400 because they get the benefit of the collateral source. And then they have their hand stuck out, so they get their $100 first. Everybody with me? They get the benefit of your insurance. And I've even seen it argued in cases that says, well, if they're going to get the benefit of my insurance, then they need to pay their pro rata share of my premium so that I have that so that they can use it. That got nixed too. Yes?
On car wrecks that I'm working on, the subrogation we have to get the subrogation amount from the insurance company, and we have to pay that out of the settlement money. So we would pay the insurance companies back for what they paid out for the damages.
Right, but here's one of the tricks that they use, and this is going into torts rather than contracts, sort of. Because you have an insurance contract, it technically is contracts. When the insurance company pays the money on your behalf, they have a contractual right to subrogation as well as a common law right to subrogation, which means they're entitled to get their money back if you make a recovery. Is that what you're asking? Now here's the trick. Some of these individuals are no longer taking, and I'll see a lot with chiropractors, they won't take insurance payments for the reduced amount so that you owe the entire chiropractor bill. And so they get all their money rather than what they agreed to take from Blue Cross. And they get their money first because it's subrogation. Keeps your damages up, but it also means you have a whole lot more to pay out to your medical provider.
We usually ask
to put pain and suffering amount solely on 3 times what
It's not. You have to argue what the pain and suffering is. A good number is 3 times. Another good number to look at is no more than 10, because the U.S. Supreme Court has said in 4 v. BMW that punitive damages should never exceed 10 times your compensatory.
But I mean, if insurance is going to mitigate the monetary damages, it's not going to mitigate emotional damages or physical damages. I mean, it's not fair.
I understand. It's not fair. I'm just warning you that's the way it works.
We always ask for reductions too.
It's what?
We always ask for reductions from the hospital liens and stuff like that too.
Yeah, they don't have to, but they can. And it goes under the common law, or the common fund theory, if you create it.
Can we refuse to use your own insurance
Yes.
so that you pay the larger bill and then the damages are?
If you have the money to pay your larger bill. Now
If you
here's,
have a high deductible plan and you have a fund set aside, would it be in your best interest?
how many people have the fund set aside?
So if you have a fund set aside and pay, you can do what you want.
Yes.
They just get sent to collections.
And then it gets sent to collections, and then it goes on your credit report if you don't have the money.
Well, then they put a lien on the home, and if you ever try to sell it.
And then they file a lawsuit against you and get a judgment against you because you owe the money. The hospitals automatically file liens. And by the way, it's illegal to interfere with a lien, which includes hospital liens. So you can't not pay the hospital.
You have to.
You have to pay the hospital. It's illegal not to. You can actually go to jail for it. Okay. Does that take care of our... What's that?
Said, no, our healthcare system is fine.
Well, at least you're not in Canada where it's free. Then you have no damages, right?
Does it work that way?
What medical bills do you have if it's all free?
No, I'm saying this Canada's legal system can do the 3 times thing.
Nobody does a 3 times. That's a rough rule of thumb. A jury could take 1 time where they could say no pain and suffering, or they can say 5 or 7 times. You can't really go in and argue to a jury, we're asking for this because it's 5 times the pain and suffering. You go in and you give them a number at your jury trial and you say, this is what we're asking for. And the reason we're doing that is because here's all the damages: property damage, medical bills, work time loss, all of these different types of damages. If the jury awards that, it's great. And if they don't, then it's a finding of fact and you're left with it. All right, family relations. Over on 604, we start off with prenups. Y'all have heard those terms before, right? Prenuptials?
In that Barbary writing class, we're dealing with a lot of that.
Okay. Now, is a contract good as far as consideration going into a marriage if you're contemplating that the marriage is going to fail to start with?
Well, I mean, the contract's valid.
It's a question about whether it's valid, right?
It's signed by both parties. Is there any consideration?
All right, but don't contracts require good faith? We're getting married. You better have good faith on the marriage. And does it violate the good faith if you're already planning on the divorce?
You're just protecting your assets.
You're protecting your assets?
It could create an incentive to stay married.
That's what I think.
It may create an incentive to stay married, but it also says in the event that things turn south, this is how we're liquidating things. Now, can you argue that somebody intentionally made the marriage turn south so that they went in and got whatever the liquidated was? So is that good faith in a marriage? Or is that fraud in the inducement on the prenup contract? If you never really intended to try to make the marriage work. Now you see why affecting domestic relations matters are tricky. However, they've actually started allowing some of them to take place. Ms. Bethune, you want to take Simeon? Can y'all hear her back there?
The wife and I before getting married to her husband was put into a prenup agreement by her husband's attorney. One of the provisions in the agreement was that in the event of a separation or divorce, the maximum payment she could receive from her husband would be $25,000. The wife didn't seek her own counsel, and her husband's attorney did not give her any insight into her legal rights. The wife signed the agreement and they were married the next day. That was 1975, and then they separated in 1982. We started divorce proceedings in 84, and in 85, the wife filed a claim for alimony. The husband refused to pay, and he argued that he already satisfied his obligations to up to $25,000 for their separation agreement. The master of the prenup agreement and was affirmed on appeal, and then the wife appeals to the Supreme Court. And the wife argued that the agreement should be void on grounds that she didn't see anything with what wife's party signed in. She also argued that the contract was signed with her under duress because of the time it was presented to her, because of the evening before the wedding, and that she was unable to complete what wife out in marriage or the expense of postponing the wedding. The husband argued that she signed the agreement, which included a clause that said each party was in the contract to be married. He also argued that discussions about a prenup were going on for about 6 months prior to the wedding, and that the wife had plenty of time to go and talk to the attorney prior to signing the agreement. The court decided that there was no reason for them to determine if the contract was reasonable because the wife was capable of making a sound decision when she signed the contract, and that if she didn't agree with the contract, she wouldn't have signed it. And they said that the lower court didn't err in finding that the wife failed to prove the rape because of the testimony from several different people that the wife knew months prior about the prenup, and that she had participated in discussions about it. And they said that that meant that she had time to consult with the attorney if she didn't know.
Is that it? Did you find the court, did you find the place in there where the court said women don't need to be protected anymore? Oh, you missed that. What'd they say about it?
They basically were saying, kind of like women don't ride, and like they don't need protection, and they can,
And that they're now more educated, more able. What'd you think about that? The fact that they're now changing the law because women are more capable now than they were back in whenever they started trying to protect women.
Shooting ground.
It is, isn't it?
They are more educated.
All right.
She was a nurse. She was perfectly capable of earning a living. It wouldn't have been as much as married to a neurosurgeon, but still.
This would not fly today, I don't think.
That was back in 1990.
I don't think that's...
This wasn't a 1960s case. The 1960s is probably when they said women are usually stay-at-home moms, homemakers, and need to be protected. Don't have as much education, but now, I guess in the 30 years that have passed, since the 60s to the 90s, women have gone from being this frail thing that needs to be protected to throw them in the deep end and see if they can swim. Yes, ma'am.
But I feel like in this case, he makes so much more than her, first of all. And then, yes, they might have been talking about it for 6 months prior, but he did present it to her right before, the eve of the wedding. And I'm like taking the sexist out of it. I feel like even if it was turned the other way and it was the woman making significantly more than the fiance who's in the relationship, and she presented the contract to him a day before the wedding, I still feel like it would be the same for both. I don't think it matters that women are now coming into their own. If we really break down the facts of the case, it really isn't fair that she was presented the contract to either way.
Well, one thing to notice how this I'll come right back to you. Notice how this fact pattern is, the lawyer didn't have it done until the day before. And in reality, he was actually early because most lawyers would have had it done right before they went to the altar. They just procrastinate that long. The lawyer may have been procrastinating for 6 months and got it done the day before the wedding, if they truly had been talking about having a prenup for 6 months. Yes, ma'am.
So I see it as, their age differences, to me, supports why a prenup should have been in place and why this is valid. He had 21 years of work experience since adulthood. She's only had 4, and they were married for 67 years, so that does not equate to you receive half of my money, and she had adequate amount of time to go read over the contract. I mean, women have evolved. I mean, they weren't on the same playing field, and just because you marry someone, that does not necessarily place you on the same playing field financially. If you're 23 and they're 39.
So the argument that there's no viability in the presumption that women are uninformed, uneducated, and readily subjected to unfair advantage in marital agreements?
I mean, this is not 1960. I mean, he had worked for 21 years building his career.
Well,
She was 23 years old.
The 1960s, they say women are not knowledgeable enough to understand the nature of contracts that they enter.
But the court ruled
Probably
that
educated
they
enough.
weren't knowledgeable enough, and she was knowledgeable. She was knowledgeable enough to find her 39-year-old college or whatever he was. So she was knowledgeable enough to read out her contract. So,
She was knowledgeable enough to go get a lawyer after all this hit the fan, right? Yes, ma'am.
The dissension says, this really goes against marriage, and I think that's what he's looking, you take those back. What's yours is mine, and what's mine is yours. So there's so many factors involved in the prenup.
That's not quite the way I've heard it. I've heard what's yours is mine and what's mine is mine.
That's not usually what they say, yes. But
Yes, sir.
Is that why the legislature states that? Because each case, I mean, some women, some men, to be fair here, have not evolved. So I mean, there's obviously some men that aren't as educated, they're married to very educated women, and vice versa. Is that why there's not any law? I mean, it's like, seems like you read about different cases. We read about cases last week in our methods class where they were all over the place, the rulings were. So, basically opposite of this. Is that why there's no law about prenuptial agreements, or because every case is different?
Well, there is law about prenups. There's case law about it. How about this? Alabama used to be able to get married at age 14. Several years ago, they raised that to 16. But that still has to be with parental consent. 18 is the age where you can get married in Alabama without parental consent. And I think 18 for the rest of the country, because that's the federal legal age, not Alabama's legal age.
Make sound decisions until you're 25. Your brain hasn't matured enough.
But there's research out there that says that your brain doesn't finish fully developing until you're 26. And that you don't understand consequences sufficiently until you're 26. So should the court really draw a line, anybody under the age of 26 that gets married, we need to protect, because the research shows that they don't understand consequences. And isn't a prenup really about consequences?
Well,
The consequence of a divorce?
using that logic, you couldn't sign any contract until, whether it be a military, enlisted in the military, or.
Oh, you can go in the military at 17 with parental consent.
But if you don't, if you can't understand the consequences, what's the difference between that and the prenup or anything else?
Well, you can go in the military at 17, but you can't drink till you're 21. You can't vote till you're 18. And you can go out there and die on the battlefield, and then you can't get a gun permit till you're 21. This is one of those areas in the law where it's just messed up. From the ages of 17, where they let you go into the military, to 26, all of the people that fall into that age group of 17 to 26 kind of fall into this black hole for one reason or another about consequences and what they can and cannot do legally. So allowing somebody to enter a contract at age 18, that's what the federal government says is legal age. Should it be higher? Well, we already talked about disabilities. You relieve a minor from the disability of a contract because they're not old enough to appreciate what they're doing, right? Well, if the research now shows it's 26 before you understand what consequences are, should we raise the legal age to 26? And the answer all of you are going to give is yes, because you all are over 26, right? Or close. I'll tell you, they raised the legal drinking age in Alabama when I was 19. The legal drinking age in Alabama used to be 19. And then they raised it to 21, but there's a little provision that says, if you've already attained this right, then you're grandfathered in. Same thing with boating licenses. If you're over a certain age, you don't have to go take a test for your boating license, you're grandfathered in.
So you have to go buy the license.
Yeah, you got to pay for the license. By the way, aside from that, if you've ever taken the boating test, go get the book and read it. And when I took the test, there were 3 questions on the test that weren't answered in the book. You can miss 3 questions and still pass. I missed those 3 questions and still barely passed. You get those answers if you take the Coast Guard class.
Is there anything you don't read? Because you read everything. It always amazes me. Because you thought, like, you're like, was there? Sorry on it. And I'm like, wow.
Yeah, I don't read some stuff.
Did you say you read, like, you sat down with the Alabama Books of Codes and just read through it?
Yep.
Okay, so back to this prenup thing. The girl was unemployed. It says she's an unemployed nurse. So do you think that had any bearing on why she didn't consult a lawyer before signing?
Because she didn't have money?
Yeah.
I don't know the answer to that, because I'll tell you this, a lot of divorce lawyers will go ahead and represent somebody in a divorce and get paid later. because they know that they're going to end up getting something out of it with which they could pay the attorney fees. Look on 605 real quick. The third paragraph from the bottom, ignorantia non excusat. Ignorance is not an excuse. That is a truth in the law and a truth in life. All right, notice also on 606, the court says, we do not depart from the long-standing principle that a full and fair disclosure of the financial positions of the parties is required. That actually is the law in Alabama. You have to have a full and fair disclosure of what your assets are going into the marriage if you're going to sign a prenuptial. And then they even say it doesn't need to be exact as long as it's full and fair. Later in that same paragraph. Over on 607 in note 2, the Uniform Premarital and Marital Agreements Act. I guess starting in 2012, they're trying to make all the states adopt this. Remember, the uniform laws, the states a lot of times will adopt it, but they'll also go in and they'll make changes to tailor it specifically to the state. So your caution on that is, make sure and actually go pull that under the state law that you're actually going under to see if they've made any adjustments to it. You'll typically find that there's comments and then there's state-specific comments about what has been changed to make it applicable to the state.
No question. What does it mean
Nope.
by
No.
failure?
Note number 2?
Yeah.
Okay.
A failure financial disclosure. What are they saying?
A full and fair financial disclosure.
So does one have to let the other know exactly how much they have?
Well, it says not exactly. It doesn't need to be exact as long as it's full and fair.
Okay.
I've got stocks and bonds in the amount, in the approximate amounts of. You don't have to give them to the penny, but it needs to be a full and fair disclosure. I've got stocks and bonds that amount to roughly this much. By the way, do y'all remember what dower and curtsy are? Do y'all know what that is? Have you ever heard the term dowry? That's how much your father pays you to marry somebody? No, that's how much your father pays that person to marry you.
Curtsy's what they keep, right? If you had a kid with them, that's what they get to keep.
I don't remember curtsy. I know it's been abolished. But the funny part about it is the old concept about you have to actually pay somebody to take your daughter off your hands and marry them and support them. That kind of got thrown out the window with the fact that spouses are incapable of protecting themselves, right? Dower and curtsy have been abolished long ago. All right, matter of baby M. Ms. Borelli? Nope, not here. Ms. Bagay.
The matter of baby M, this was from Supreme Court of New Jersey, 1988. Husband and wife wanted to have a baby, so they made a contract with a woman to carry the child. And upon delivery, she was to relinquish all rights of the child to the husband and wife. But the woman changed her mind. The husband and wife sued, and the court upheld the contract, saying that the woman was supposed to relinquish the rights of her child to the husband and wife. The woman then appealed, and the issue was whether a party to a contract to relinquish her legal rights to her child, could that be upheld? And the court said no. The reasoning was that the servicing contract is invalid because it conflicts with the law of public policy and with of that state of New Jersey.
The quote in here on 608, we find the payment of money to a surrogate mother illegal, perhaps criminal, and potentially degrading to women. All right, they later point out in the opinion that it is illegal to pay money to somebody for you to adopt their child. When you do adoptions, you have to actually do an affidavit that says, I haven't paid anything of value to anybody in order to adopt this child. I was fortunate enough to file 3 adoptions this week. They're the best kinds of cases that you can do in the law, period. You go in and you're creating a parent-child relationship. Everybody gets in there and boo-hoos because you're so happy. The other boo-hooing that goes on in the courthouse is divorce court, where they just split up everything. That's the unhappy boo-hoos. The adoptions are the happy ones. They point out it's a contract of coercion over on 609. The nature of the mother's irrevocable agreement prior to birth, even prior to conception, to surrender the child to the adoptive couple. They say that's coercive. Conflict with statutory provisions in paragraph A toward the bottom. Law prohibiting the use of money in connection with adoptions. That's a good thing to test on. It also happens to be the law. Laws requiring proof of parental unfitness or abandonment before termination of parental rights is ordered or an adoption is granted. So what do you have a right to? Where are they pointing out? You have to be found to be unfit first, right? Before they can take away your parental rights.
So they give you all the opportunities in the world.
Usually yes, but not in closely related adoptions. They don't have to have home studies in those. Number 3, the laws that make surrender or custody and consent to adoption revocable in private placement adoptions. You have the right to revoke your consent.
I think that is so much.
Well, let me walk you through a couple of examples, because we had a close friend that was adopting a baby and had gotten the pre-birth consent of the mother. And then there's a period of time that the mothers can revoke it in Alabama. So having the pre-birth consent of the mother, our friend went to the hospital and held the baby and loved on the baby. And 4 days later, the mother decided, I'm keeping the baby.
They shouldn't be able to change it with all its hormones and
Well, what do you think? Should they be able to change their minds?
because there was a reason you decided to go right.
What about postpartum depression? Now, I'm going to tell you something. Men don't suffer postpartum depression. That's something that's strictly female. They don't suffer it because they don't bear babies. Yes, ma'am. Yeah, 5 days, I think, in Alabama to revoke your consent. 5 days or a week. It's different what? Guardianship's not the same. Guardianship is very different. Adoption is you're permanently terminating the parent-child relationship in order to create new parent-child relationship. Okay. No, she can consent to it, period. The only other time if it's involuntary is, one way is they have to be unfit. And there's about 8 different grounds in Alabama to terminate parental rights other than consent, like to an adoption. And here's another question. A father of a child, can he just go in and say, I want you just to terminate my rights. I don't want to have anything to do with this child. Will the court do it? In Alabama, you cannot bastardize a child. Somebody's got to support that child.
You can sign away your rights and still be ordered child support, right?
Absolutely. There was I think it's MDC is the name of the case. I can tell you the judge that wrote it is Justice Mike Boland from here in Jefferson County. Says that terminating parental rights does not terminate parental responsibilities. So even if your rights are terminated, you still owe child support until the child is adopted. Yes, ma'am.
Well, my ex-husband, he signed his parental rights over, and they stopped the child support. He had to pay arrears. And he just came in and said, I don't want the right, I don't want the responsibility anymore. And the lawyer did the paperwork.
The court's not supposed to do that because technically it's called bastardizing a child.
I didn't mind.
And yet they do that every day when they create a birth certificate without a father, right? So they won't allow you to take a name off, but they will allow you to not put a name on. Now, you want to know the trick behind that? If a woman goes in the hospital and says he's the daddy, then the state goes after him to pay the expenses of childbirth. But if she goes in and says there's no daddy, then Medicaid pays the bill. That's you and me, by the way, our tax dollars. Yes, who had their arm up over here? Go ahead.
Like a young mother or something is giving up the rights of her child due to being young and unfit or something. But in this case, without the being able to be a child, so that's where I'm really
Well, at the end of the opinion, they say the child's got two parents. The surrogate mother, who's actually the biological mother, and the daddy, which is your seed argument. So the child's got two, and they directed the court to send it back to determine the mother's visitation. They were okay with the father having custody. But the natural mother, because she's not been found unfit, and she can't, by law, before the birth or even before conception, waive her rights to having custody of the child or even, motherhood of the child. Now that brings up another good point since you brought up the seed. What about women who go to the sperm bank and pick up and get inseminated and now have a baby? Who's the daddy in that case? How about under the baby M rationale? Who's the daddy? The sperm donor is, right? Now, is he responsible for child support? In Alabama, you can be because you are the daddy. There are some crazy stories to tell you about DNA and babies.
I thought when men donate sperm in those cases to fertility clinics, they give up their rights
Until the mother signs up and receives Medicaid, and DHR goes after them as a daddy to get payment of that Medicaid back. Oh no, it's not anonymous. They keep careful records. Yes, ma'am. I guess you got to give that up as a way of earning money.
Every man in here squirming.
There was a hand up over here.
I just had our son in the hospital here now, and they wouldn't let my husband sign any paperwork regarding him because they couldn't prove that he was my husband's child. So any proof of the baby being born, I had to sign. And my husband was saying, this is my child.
Yeah, you sign it saying that yes, we are married.
After we did the certificate, we can send it, they couldn't prove who the father actually was, but you could prove that the baby was mine.
How's that make you feel?
Because my husband was,
You know what the hospital's just accused you of, right? Sleeping with everybody but your husband. Okay. Well, in Alabama, the husband is presumed to be the father. And you're supposed to be automatically put on the birth certificate if you're married.
Married. But they're saying that the custody of him, from court to court, or taking him home, or any procedures that he had, I had to sign for it. The husband didn't sign for it. And they just said that's how it is now.
Did you know that Alabama also has maternity actions?
Has what now?
Maternity. To determine who the mother is.
Because of egg donation or egg?
Well, because sometimes the hospitals get babies mixed up.
I watched the live.
And you got to test who the actual mother is. So does that cause a chilling effect on those who would donate to sperm banks? If you have the possibility of being brought back in order to pay child support on this child? But under Baby M, because your DNA is related to the child, you are the daddy. Right? She was the biological mother. The donor would be the biological daddy. Now do you see why they don't want to have contracts for personal domestic relations?
I have another question.
Okay.
If it, in this situation, if it was hypothetically a little different in that the mom and dad had their sperm combined and they're officially and they got, I guess, already judged, in that case, would the birth mother have any claim to the child?
Like Kimber and
If the mom and, if the married couple were the biological parents,
So she's like a host body.
would the birth mother at that point have?
Was it the birth mother's eggs or somebody
No,
else?
it was the mom's eggs.
Oh,
I mean, like the wife's eggs.
Like what Kim Kardashian does. They both pay some of it.
who knows? I mean, what they said in the Baby M decision was that she's the one that bore the child for 9 months. But if it's not her egg, you can make the argument that it's not her baby. Look at the last sentence of this opinion. Moreover, the legislature remains free to deal with this most sensitive issue as it sees fit, subject only to constitutional constraints. Remember how we've talked about the fact that the courts can reach decisions and the legislature may have to pass a law to fix it? This is where the court is actually inviting the legislature to go in and fix it. Huh? The last sentence of the opinion, it's on 612. So not only does the legislature have the ability to make those changes, sometimes the court's actually invited. Look over on 614, the middle of the page in the paragraph, reasonably assured expectations. California surrogacy laws are some of the most favorable in the United States for recipient parents. So if you're going to draw up a surrogacy contract to use here in Alabama, could you put a provision in your contract that says the laws of the state of California apply in this case?
That's why you have to go with wherever you do the contract.
Choice of law?
No, it's choice of law. You can put the fact that the state of California's laws are going to govern this action. Everybody with me? Now, does that mean that Alabama's going to enforce it? You're right, it doesn't. There's a case you'll get later in law school. It's GMC versus Baker, I think. And it says whenever, on full faith and credit, that courts have to give full faith and credit to the judgments of other states, but they don't have to with the state's laws. So Alabama has the right to pass a law that's not the same as California's, and if they do pass a law which is in conflict with California's, if you bring an action in an Alabama court and try to use California laws, Alabama can refuse to do that because Alabama's laws are different. But you'll run into that under full faith and credit. Yes, ma'am? Sometimes. I'll tell you this, when you get to conflicts of laws, you'll study choice of laws. I'm just telling you that you could put a provision in your contract that says the laws of the state of California govern this contract, but it doesn't also automatically mean it's going to be enforced that way. All right, at the bottom of 614, there's a French case by the name of Manuel Wackenheim versus France. Did y'all read that? Apparently, a popular form of entertainment in France is tossing midgets. Did y'all not read that?
It's the look he gave me when you said that, because I'm short.
And the funniest part about this was that afterwards, the dwarf Mr. Wackenhut brought a claim against France under the International Covenant on Civil and Political Rights, saying that he had the right to contract himself to be tossed about in French bars. All right. Questions down at the bottom. Are there any commercial transactions, commercial sales, prostitution that might be thought of as implicate dignity? They're saying it wasn't dignified to throw midgets. That is what they said. That it impairs upon the midget's dignity to be tossed about in a bar. Should assault to a person's dignity be a ground for non-enforcement of a contract? All right, y'all are taking torts, right? What is an assault?
Imminent apprehension of a harmful effect.
It's an unwanted what?
Well, assault would be apprehension of it, the immediate apprehension of an unwanted harmful or physical contact.
An unwanted contact, right? If he agreed to it, is it unwanted? So it's not an assault.
My child's a little person, so I'm going to speak to this from a non-objective standpoint. But we're in a huge number of little people groups and little people American Association, etc. And this is an ongoing argument because the little people who participate in things like midget wrestling and all of that.
By the way, there's midget wrestling tonight over at the Mora Shrine Temple in Irondale.
Understanding, so the people who participate in that, they're like, this is how we make our money. Our people who are in harmless, city world's smallest person, whatever, their argument is that this is how we make our money, this is our livelihood, and just because some average-type people who have nothing better to do than stick their nose in our business don't like it, it doesn't mean they're not entitled to the same things. I mean, average-sized wrestlers, they get to have wrestling without controversy, right? So it's like a big controversy. I mean, I think the LPA actually has a couple of suits in different states trying to stop these type of activities, and the people who participate in it don't want it stopped. It's a controversial issue.
Okay. That's fair enough, and just like the LPA, Mr. Wackenheim in this case wanted to enforce his rights to be able to work. All right, so is there any contracts that would affect a person's dignity or implicate a person's dignity? Prostitution. That's one of the notes. That's actually in here. Organ sales and prostitution. Can you sell somebody your liver or a piece of your liver? You can't give it all to them. Oh, we're talking about selling body parts. We're getting to brothels in a minute. Not in Clark County. That's where
I think taking away people's rights when they want their bodies to be stuff like what's the difference between prostitution and just saying women's nationals and
well, should you refuse as an individual to enforce anybody's right to prostitute themselves?
I mean, if you're a consenting adult age, I mean, this is me personally.
All right, it's illegal in Alabama, but it is legal in some parts of Nevada. So should somebody be able to legally prostitute themselves? Or should society protect them from the indignity of selling themselves?
No. It's not society's decision.
Well, that's what this paragraph, that's what this whole section is about. If it's not dignified to allow somebody to toss a midget, and that's the terms that they used in the book, and they refused to enforce that because it was not dignified, how far do we draw that line between, like, organ cells? Can I sell you one of my kidneys?
Well, you're taking advantage of someone that's not in a situation to make a rash decision. I mean, they're making a rash decision because this could be a loved one, and you're taking advantage of their duress.
All right, so what is the sale of an organ? Okay.
It is.
Well, that's what I'm trying to get to. Is it any different than just donating it to a friend? Well, you understand that there are more than one way to buy something, right? You can either chuck out cash or you can barter. Now, there was an episode of a TV show this past year where somebody needed an organ and somebody else needed another organ and somebody else needed another organ, and there were 8 people that needed organs, and some of them cross-matched to the others but not to their own. So they set up a situation where this one would number 1 would donate to number 2, number 2 to number 3, number 3 to number 4, all the way down to where number 8 donated back to number 1. Is that the sale of an organ?
No.
Are you giving anything of value in order to receive an organ? You're giving one of your organs.
Yeah, but it's legal to donate. It's legal to donate an organ. So if
But I can't sell my liver on the black market.
right, if I needed a kidney and somebody else needed a give me an organ.
A lung.
A lung, better word. Thank you. And I traded my lung for his kidney. I mean, there's fair point, but and there's nothing wrong with that because you're not selling it on the black market. You're not doing anything that would be considered nefarious to get it. But if you've got $50,000, you jump ahead of somebody on a transplant line.
They do that.
Well, that's like organ sale.
You know that's different.
Should you regulate it? Should you make that illegal because it affects somebody's human dignity?
Not that it affects their human dignity, but the fact that there's a transplant list, and based on need, the fact that you could jump ahead of someone who's a week from dying when you've got maybe 6 months, that's where the difference lies.
Yes, ma'am.
You can actually do a program that you can, like, if you know somebody who needs a kidney, through the organ donation, you can sign up to donate your kidney. If you're not a match, because they convince you to donate your kidney, when one is a match for them becomes available, they move ahead on the list because they've got another kidney into the shred. And the second thing is, big in international news right now, there was a kid who sold his kidney on the black market for an iPhone and an iPad.
Yeah, that Chinese kid, right? Chinese kid wanted an iPhone so bad, he sold a kidney, and then his other kidney died, and now he's dying.
So you really should regulate it.
Yes, ma'am. Shh. Go ahead. Well, I think we've already reached that conclusion that it's okay to barter for one, but you just can't pay over cash for someone, right?
A lot of people be getting kidnapped. If you sell kidney, I'm saying,
There are. Is it what? Technically, no, because they're human body parts. I think they're exempted specifically from the UCC because of that. Yes, ma'am.
Are you talking
have dignity still?
We're trying.
So if I go to Mardi Gras, am I supposed to go down Bourbon Street and start preaching to people about dignity at Rick's Cabaret? And if I go in and I get my dad a lap dance, am I without...
We're getting to lap dances now.
Okay. All right. Where you're going with dignity and contract. I mean...
But that's like moral, it's not really dignity. Like that's more like,
I mean, car salesmen aren't very...
Well, it's hard to draw that line between morals and dignity, isn't it? All right, next question I wrote down for discussion is, what about exotic dancers?
They're just trying to make it your body.
Yeah, they're just trying to get an education.
Okay, we have it's a your body.
What about massage therapists?
Hold on, we're getting there. Exotic dancers. Let's take them one by one. Female exotic dancers. Because there's male exotic dancers too. Chippendales. Does it affront human dignity for them to get out and do whatever it is that they do?
If they consider it. And that's what we're talking about the dwarf. And they've considered it. And it's a way of making money.
So should we enforce those contracts?
If it's not breaking the law. I mean, how would that be breaking the law? Some people consider it immoral, but as far as the law of man, that's not breaking the law.
There are some places where strip clubs are illegal.
well, those are like small towns.
But that's
In those,
different.
you can.
And I agree, that's different, but if it's not illegal.
Yeah, it is.
Yeah,
All right.
I agree.
Where we live, you cannot have one in the city limits. They're allowed in the county.
Since we're now to strippers, we'll go ahead and talk about that. That's the next on the list.
Well, and there's some strippers that strip all the way down, and there's some that can only strip
Well,
at a certain point.
Now let's talk about larger metropolitan areas like Atlanta. They do get completely nude. Is that illegal in Alabama? Absolutely. Completely nude in Atlanta. Now, is it because they have less morals than Birmingham? I'll have to say it's whatever the public votes as being their public policy, and the legislatures over there, whether or not they're the city, because you pointed out that it's usually up to cities, or whether or not it's the state, whatever they pass the laws as is the legislative declaration of public policy. So is Georgia really a den of debauchery? Or is it just Atlanta? What?
I don't think it's either.
All right, now now in Alabama you can't have anything exposed. And people break that law all the time. And if the police are in there and catch them, they arrest them for it. Yes, sir.
So let's say a guy goes to a strip club, he gets all amped up, he leaves, and then because he's amped up, let's say he commits a rape. Could the female that he raped sue the stripper for proximate cause?
That's a trick question. You want me to answer it the best way to answer it? You can sue anybody you want to for any reason. It doesn't mean you're going to win.
What about like helmet laws, motorcycle helmet?
Well, does that impair your dignity?
That's what.
It's a law, right?
But dignity is for, like I'm reading the definition, it's for your own sake. So if you choose to do it, but the organ donation, I mean the organ sales, that can harm somebody else, like the kid that, you know.
Well, here's the bottom line on it. Should I tell you when your dignity is compromised?
No.
Or should you be the only decision maker as to whether or not your dignity has been compromised?
Age plays into that.
I'm thinking society's going to collapse if they don't.
Yeah, if you're under 26 and don't understand consequences, then all these nude selfies you've been putting on the internet, they'll show back up. And believe me, that's a problem with kids. Sexting. The problem is, it is illegal because if they're under the age of 18, they're creating child pornography. And the problem is, does the federal government now prosecute that, or the state government? Because that's illegal indecent material under state law. Is that illegal for them to create it, even if it's themselves? The answer is still yes, it's illegal. That is a public policy decision by the legislatures, both Congress and the Alabama legislature, that you just can't do this. So yes, there are laws that are passed, but then there's that gray area above what's illegal and what goes up to your dignity. And then there are things which don't implicate your dignity. So there's that huge gray area in between that if you get a contract, you need to be prepared to argue that this should not be enforced on public policy of it impair somebody else's dignity. Yes?
I actually feel like in other countries, you have suicide and stuff like that. Like, yeah,
Dr. Dvorkian, huh?
Yeah, but like, what's the difference between saying, I don't live my body anymore at all, and saying, I just don't want a piece of my body anymore? And, you know, getting monetary gain off that piece of your body. Say you're living a kid. You know, like this.
Well, it's not just that, but do you also recognize, because you hear these news stories, that people who have dead family members who've donated organs will actually visit with the people who received the organs and think that their loved one is still alive in that person. I think that gets into a spiritual context, and we're not going to go into spiritual because it's bad enough going to dignity. You can see how it's turned to a lively discussion. There's another thing in here about, I think we're coming to it. Turn over to 617, remedies for breach. I've got almost that whole first section highlighted because it's actually got good material in it. If you haven't read it yet, please do read it. In the United States, as in England, which are common law governments, the preferred measure of damages is dollars. But in civil law countries, and civil law would be continental Europe, they're all civil remedies, which their default is specific performance rather than money. And in England, the equitable remedies were characterized as extraordinary, ordinary being money, equitable remedies being extraordinary. They also say that equitable remedies are discretionary with the judge. They're discretionary in common law countries, but it's default over in civil law countries. Now, how many of you know the kind of law that's actually applied over in Louisiana?
It's Napoleonic.
Napoleonic Code, which is what? It's civil. So in the federal courts over in Louisiana, the default is money. But if you're actually going under the Napoleonic Code in Louisiana, their preferred remedy is going to be equitable because they're a civil law or a Napoleonic Code. Yes, ma'am. Well, that's usually federal. Well, if it's destroyed, then you can't get it back. Okay? If I agreed to sell you a 57 Chevy, and I change my mind and don't sell it to you after you've given me a down payment, what would you want? Would you want your money back, or would you want the 57 Chevy you had agreed to buy? They'd probably enforce the sale of the car rather than just giving you the cash equivalent of what it's worth. Wherein most common law, it would be whatever the cash value is for your monetary damages. All right, there's a lot of equitable maxims in here on the top of 618. One who seeks equity must do equity. You have to come into equity with clean hands, and equity aids the vigilant. not those who slumber on their rights. They missed the rest of that. All right, so specific relief. Campbell's suit, which we've already done before. Ms. Clark.
United States Court of Appeals. Campbell's suit went into a contract with a farmer to grow carrots, a specific type of carrot. And when they did, they agreed to a specific price on these carrots. And when they grew the carrots, the farmer ended up growing the carrots, but then selling half the carrots to Campbell's suit and then the other half on the market. And Campbell's suit ended up suing them for specific performance because they wanted.
Well, they were slicker than that.
Well, they ended up upping the price and then saying that they weren't going to deliver them to Campbell.
No, what they did is they let their neighbor sell them on the market.
Right, let the neighbor sell them on the market. And then,
So it couldn't be directly traced back to them, right?
right. But
Okay.
And then Campbell sued them for specific performance. At first they were saying that they couldn't do it because it wasn't under the objective standard. They weren't specific enough, but then they were saying that because Campbell's put value on the carrots, that they could get the specific performance out of it. Because they valued the carrots that they were putting into what they put the value on them.
So they allowed Campbell's to get the actual carrots themselves, right? Rather than the money for them? That's what specific performance is, or specific relief, is to enforce the actual deal. A few things you need to notice in this opinion. On 619, in the paragraph that starts with the bracketed, the court said, very last sentence says, inadequacy of the legal remedy is necessarily a matter to be determined by examination of the facts in each particular instance. That is a foreshadowing of what the court's going to do. It means we're not creating a general rule of law. We're looking just at this case. And the facts of this case indicate that this is what ought to be done. So no, they're not saying every contract is entitled to specific performance. They're saying every case is fact specific, and under these facts, they're entitled to specific performance. The next thing you need to notice is, next to last paragraph, it starts with the trial court concluded. They say, this we think is not a pure fact question, like a finding that the Chantenay carrots are of uniform color. It is either a conclusion of law or of mixed fact and law, and we are bound to exercise our independent judgment upon it. What they're telling you is that they're addressing a standard of review. Did the judge decide this, or did a jury? The judge decided it, right? Why did the judge decide it? Well, the judge decided it because juries cannot award equitable relief. That's something you always need to keep in the back of your head. Juries only award dollars. The judge is the one who determines whether or not it's equitable relief and whether to award it. So when they say that it's not a finding of fact, what they're saying is that we don't give deference to a trial court's decision on facts. How many of you have heard of the Ortenis rule? Every one of you, because we covered it last semester, right? That's where we talked about the fact that the judge hears testimony from live witnesses in open court, and they have the opportunity to observe the witness and determine whether or not they're telling the truth. Remember, when it's a finding of fact, the judge is given deference on his opinion as to what the facts are, because the judge had the opportunity to observe the witnesses and to see whether or not they're telling the truth. In this case, they're saying it's not a pure fact conclusion. So they're setting it up to say, we don't want to take the findings of the trial court and abide by those. We want to make our own findings. And the way they do that is saying that if it's a question of law, questions of law are reviewed for what? They're de novo, meaning the appellate court gets to make the same decision on the facts or on the law as what the trial court did, so it's a de novo review. And in fact, questions of mixed fact and law are also de novo. So what the court did here is they said it's not just facts. Facts would have to give deference to the trial court. It's a question of law, whether or not it's completely law or mixed with facts. Therefore, we get to decide the standard of review on it. And they do that de novo, not whether or not the judge has committed an abuse of discretion. You don't get that by reading this case. That's why I wanted to explain to you what they're doing here, so that you see the trick that they're using to make a decision brand new without giving deference to the judge's findings of facts. That's how they set up this equitable relief. Any questions?
De novo is when an appellate court...
De novo is just a brand new decision. De novo is from new.
Okay.
From new is de novo. All right, look at note number 2 on 620. Deprivation of a loved one's companionship and the loss of a firm's goodwill. Can you measure in dollars the loss of companionship of a loved one?
They have those, what do they call it, loss of affection cases now?
Loss of consortium?
Or when the wife sues the mistress or whatever.
Almost. Let's say that you're involved in a car wreck and you're banged up pretty good, and when you go home tonight you don't feel like performing your spousely duties. That's the loss of consortium. They say it's the loss of a loved one's companionship. Read into that. That's not just emotional and physical and monetary support. That's affection as well. That's everything that goes with the marital relationship. Can you put a dollar amount on every time that you lost your spouse's companionship? In Alabama you can, because it's called loss of consortium, and the damages are awarded to you in dollar amount.
So how do they determine that?
The jury comes up with a wild number. But it's not prostitution, because that would be
It
illegal.
sounds like prostitution. It really does.
It depends on how you term it. All right. Money damages are often viewed as too speculative and therefore not compensatory. Notice that. And then I saw a term in here I've never seen before. Sick as an old hound dog who ate a rotten skunk. The very bottom of 620. Sick as an old hound dog who ate a rotten skunk. I guess you could put possum in there too, right? On 621, UCC 2-716. That's an answer to the Campbell suit. Ms. Clark,
Yes, sir.
you want to get Klein versus Pepsi?
Where he's all done, yeah.
Did you just do one?
I just did it. I just did Campbell soup. Yeah, and then it's already-
Mr. Clayton, Klein versus Pepsi.
Plaintiff began searching for a used jet. He contacted Patrick James, president of UJS, to inform him of the aircraft owned by the defendant. After inspection by his father and defendant, plaintiff had the jet flown to Arkansas for personal inspection. Thereafter, plaintiff gave James $200,000 and told James to offer $4.4 million for the aircraft. James selects the $4.4 million offer to James Wash to serve as the broker for the defendant. Wash counter offered $4.7 million. After negotiation, James and Wells settled for $4.6 million, and James planned to sell the aircraft to the plaintiff for $4.75. The trial judge determined that a contract had been formed at this point. The defendant failed to deliver the aircraft in breach of the contract, and the trial judge ordered specific performance, i.e. deliver the jet for the agreed upon price. I guess the issue was specific performance appropriate in this type of contract, and it was held that no specific performance appropriate for goods are unique in other proper circumstances, and in this case they found out that there was other aircraft on the market that they could have bought. And that's what I think ended up finding that aircraft.
I think that's what the note said, right? He ended up buying the next model up. So what's the difference between this and the Campbell suitcase? Well, they were saying that they were unique, but there were how many tons of those carrots? Several tons of those carrots. Now, in this case, how many of those airplanes were there? Well, there was a handful. There were some. So it wasn't that it was completely unique, but it was unique enough that there were only, what, a half a dozen different airplanes like it? And it wasn't a small enough group for them to order specific performance like the carrots, which was tons of it, but just a particular variety. One variety that apparently Campbell's puts a lot of trust in. If you remember back in the Campbell's case, they said we only use 30% or so of the carrots to actually dice up and put in the soup. The rest of it we puree and make soup out of. So I don't know how special your carrots got to be if 70% of them are just pureed anyway. You can puree any carrots and put food dye in it and it matches the color, right? Yes, ma'am.
In Campbell's thing, did it matter that Campbell's provided the seed for the carrots? Did that affect any of the...
They didn't say it did, but I'm sure that probably came into weight on the judge's decision. All right, on 622 at the bottom, there's another general rule of law for the court's decision process. If the findings of fact are based on determinations of witness credibility, are consistent, and are corroborated by extrinsic evidence, they are virtually never clearly erroneous. What that tells you is that the judge can be reversed if his findings are clearly erroneous. However, where it all looks like the evidence is consistent, it's never going to be clearly erroneous. In the next sentence, decisions to grant specific performance are reviewed only for an abuse of discretion. That's if it's based on the facts. In the Campbell suit case, they said it's not a question of facts, it's a question of law, or a mixed question of facts and law. So there's another way they distinguish these cases. The Pepsi case was fact-based, and the Campbell suit case was a law-based decision. On 624, it mentions UCC 2-716. Look on 625, note 3. Common law's preference for damages over specific performance is not found in civil law countries. Well, there are very few common law countries. The United States and England are two of the big ones, or the two big ones. Continental Europe is civil law. One of the other differences in civil law is that you don't get jury trials. The judge is the one who makes the findings of fact. And in fact, in civil trials, civil law country trials, the judge is usually the one that asks questions of the witness, not the attorneys. It's kind of more like an inquisition rather than a trial. And then they made an exception under the international law, even though the common law preference is for damages. The court's not bound to enter judgment for specific performance unless the court would do so under its own law with respect to similar contracts of sale not governed by the convention. So there's the loophole that gets the United States and England out of ordering specific performance. Morris v. Sparrow. Ms. Cockrell.
Okay, so Archie Sparrow was hired by Morris. Yes, Archie Sparrow was hired by Morris to tend to his property, like his ranch, while Morris went away, and the exchange was going to be for money and a horse. So while upon satisfaction of the work done while Morris was away, so Morris knew Sparrow knew he was doing a good job, and so he trained to get the horse that he wanted. It was a horse that could not be ridden, and while the owner was away, he trained the horse, maybe broke it where he could ride it, and it was now possibly running to be a really good, maybe working horse. Morris got home and decided he would pay the $400 for the horse. That's the bottom line of it. He says that
Because the horse was worth a whole lot more now than it was when he made the bargain.
Right. So he decided he wanted to keep the horse, and Sparrow sued for specific performance because he wanted the horse. And so the issue before the court was, would the grant enforce the contract and grant specific performance over monetary damages. And the court decided that the specific performance, well, the district court did it, but it was appealed, and the court determined that the specific performance was granted because this horse was at the unit.
Because of the training he had invested in the horse. Do you remember a similar case about somebody moving onto a farm and building a house on it? Yeah. Did he get the house? Because they're unique, right? The house was unique. Anything real property is going to be unique. But in this case, they found because of the horse's training, the horse was unique as well. All right, another term you need to notice out of this case. Well, the rule of law, although it has been held that equity will not ordinarily enforce by specific performance, contract for the sale of chattels. And this is the last paragraph on 626. It will do so where special and particular reasons exist which render it impossible for the injured party to obtain relief by way of damages in an action at law. First of all, what are chattels? Personal property. It's not real property, but it's personal property. So anything in the sale of personal property, if it's special or particular reason exists which make it impossible, then you can order specific performance. At the top of 627, that next to last sentence says, the Chancellor had a better opportunity than this court to evaluate the testimony of the witnesses. That is the or tennis presumption, even though they don't tell you it. That's the reason why they uphold the trial court's decision. Look at note number 2, possession of a pet dog, where the dog has special subjective value based on one party's sincere affection for and attachment to it, as opposed to a sentimental assumed for the purpose of litigation out of greed, ill will, or other sentiment, or motive similarly unworthy of protection in court of equity. So are they going to award specific performance for pets? If your affection for the pet is genuine and sincere, it looks like they probably will. Now let's take that one step further. Let's say that you and your spouse have a pet. Let's say it's a dog. Both of y'all love the dog, but you're going to get a divorce. Who gets the dog? Shared custody, right? No prenups. So you want shared custody of the dog, right? can the court give you shared custody? No. A dog is a chattel.
In California.
It's not a child. Yeah, but that's California.
So it's just in Alabama you're saying no?
In Alabama, you don't get visitation with a dog. Yes, ma'am. Oh, you're not supposed to do that. A dog is not a person. You say visitation for kids. Well, now, if they agree to it, that's a different thing. But a court cannot award custody and visitation. They can divide up property, and a dog is a chattel. It's personal property. It's not a person with whom custody and visitation is ordered. That's the whole point, is that you can award the property, but you usually reserve only custody and visitation with people, or specifically children. All right, specific performance and investment on 627. The important parts I got to are in particular on note 3, personal service contracts. The court will not order specific performance of a contract to provide a service that is personal in nature. One concern is the difficulty of passing judgment on the quality of performance. A second is the undesirability of compelling continuance of personal relations after disputes have arisen and confidence and loyalty have been shaken. All right, let me give you an example. You're an artist, and I want to hire you to paint my portrait. But somehow I've insulted you and your artistic ability, and now you don't want to paint that portrait for me. Can I sue you to specifically paint my portrait? Should I be allowed to complain if it turns out to be a caricature? That's what a personal service contract is. You're getting somebody to do something specifically, not providing a product, but doing something personal. And that's the illustration of why it gets difficult to enforce it, because if you're mad, you might do a caricature and it may not be flattering. Rather than doing a artistic and realistic portrait. The next one is imposing what might seem like involuntary servitude. Y'all do know that involuntary servitude is illegal, right? Unless you play football. Number 2.
Yes, sir.
Canned tomatoes.
Yes.
About the fact that they ramped up for production. They spent a lot of money preparing for the season, and it was going to be a lot of work in a short period of time, and the court found that their preparation for that entitled them to specific performance because of the money they had invested and the preparations they had made. That's another way to argue for specific performance, but it's still fact specific, right? So that's one of the general rules, is it's still fact specific. Involuntary servitude, is that illegal? Doesn't the 8th Amendment? All right, and when I make the joke about football, do they actually compensate college football players for injuries that they sustain?
Yes.
Other than just paying for their scholarship, do they actually compensate them for injuries?
I don't think legally they can.
No, the NCAA won't allow them to do that. Is that a full-time job for college football?
Yes. Yes.
Some places it is. Yeah, there's supposed to be rules against it, but the amount of time and effort they put into it,
They're getting a free education out of it and they volunteer for it. It's not like, hey, you have to come play football here.
Yeah, but aren't there other people there who get a free education just because they're smart?
Yeah, but it's not free if it's contingent.
Sure it is. Sure it is.
Universities, the SEC, all these things, make millions and millions of dollars off.
Yeah, they can lose their scholarships.
They can't, but it's...
Yeah.
And that's true.
So, I mean, do football players have to actually perform? Without technically any compensation, right? Is that a form of involuntary servitude? But it's not compensation. The NCAA's got rules against compensation. And the funny thing on Facebook going around is it may have been illegal to serve them Big Macs at the White House.
Like they also serve food though, don't they? Or do they not? When teams go?
I don't know the answer to that. I've never been there.
And I wondered, what do they, that was my question. Why was it an issue? Okay.
Because people want to fight over something. All right, next paragraph down, starting off with cats in the case above. The difficulties courts face in monitoring performance. And this is something you need to get out of this material. Along with the concern that the party compelled to perform by a judicial order may not have the best incentives to perform well, create a risk that the individual will take less than ideal actions, that they will not be made fully accountable for their actions, so-called moral hazard. Now, one of the things about specific performance is that the courts, in order to monitor whether or not the person's doing what they're supposed to, they have to actually monitor it. How much effort does that take from the court?
Want somebody to taste somebody to do
It can take a substantial amount, right? Negative injunctions, number 4. Negative injunctions are real easy to order. Positive injunctions are not. You know the difference between the two? Yeah, a negative injunction is a cease and desist. And a positive injunction is you have to go out and do this. So that's the difference between those two paragraphs. The personal service and moral hazard, that's an affirmative injunction ordering somebody to do something that they may not be incentivized to perform, but a negative injunction keeps them from doing something that they're not supposed to do. Over on 630, injunctions especially common in the world of sports and professional athletes. Look at the next case down there, the New York Football Giants versus the Los Angeles Chargers. Do you think people would actually sign a contract with a college athlete in violation of the NCAA rules?
No.
And keep it secret so they can play in a bowl game?
No, that would never happen.
All right, Ms. Colburn, the gas company versus AMCO. All right, Ms. Collins. Can y'all hear back there?
To provide propane gas distributing system to the residential development in Jefferson County, Missouri. Larson asked the court for a mandatory injunction that would stop the continuance to breach the contract or any alternative damages. The term of the contract was as promise to pay and co-portion for gas for the amount of commercial propane gas and co-own, maintain, operating storage, and operating facilities. And so decided to cancel the agreement during 1972 to 1973 to experience the shortage of propane gas and voluntarily placed all customers in an 80% a location, including clearance. April price increased by 3% per gallon. Notified of termination is September the 21st because the lack of maturing contract was for a long period of time.
Mutuality.
I'm sorry, mutuality, yes, sir. If the contract was breached, it would not be in the best interest for the public interest in providing purveying to the other retailers. The mandatory injunction shall remain. The court decided that the mandatory injunction should remain in place because it would be in the best interest of the public. It would place a hardship upon the residents because of the shortage. The sixth performance is properly granted in this case is reversed and remanded, calls to district court. That's all I know.
Okay. How many of you know what's going on in St. Louis, Missouri right now? Didn't that big storm just pass through there? Dumped a lot of snow and ice on them? Isn't that the same one that's coming this way? Would it be a hardship for them to be frozen into their homes and not have gas to heat them? Is that a good public policy decision? So they brought up at least 4 different arguments. On 632, fourth paragraph from the bottom, AMCO contends that 4 requirements have not been met. There's those 4 requirements. And then the court picks all 4 of them apart, right? Look at the next to bottom paragraph. While the court may refuse to grant specific performance where such decree would require constant and long continued court supervision, it's a discretionary rule which is frequently ignored when the public interest is involved. Now, is there another case you can think of, Alabama, where maybe a court's got an injunction for the Department of Corrections to reduce overcrowding in the Alabama prisons? Are y'all familiar with that? It was just on the news this morning about building mega prisons to get out from under that injunction so they can actually comply with what federal court has told them to do. That federal court still has the mandatory injunction in place, and they are still having hearings about why the Department of Corrections is not abiding by the court order and alleviating overcrowding. So, frequently ignored when public interest is involved. What's the public interest involved in the Alabama prisons? Avoiding riots and breakouts, which would potentially put the public in threat of danger, right? All right, axiomatic that specific performance will not be ordered when the party claiming breach has an adequate remedy at law. That's in the middle of 633. And it's especially true where the contract involves personal property as opposed to real estate. And then restatement section 361. On 634, UCC 2-716. In a couple places in the notes, note 1 and note 2. All right, Ms. Colburn,
Yes.
Northern Delaware versus Bliss.
Okay, so the plaintiff and defendant, they entered into a contract to update a steel plant. The defendant was too slow completing the work as required by the contract. They wanted a court to order that they hire more workers to complete the contract. The issue was whether the court should issue the order or not. And the court basically said that it's not going to become involved in supervising that project because it would be impractical to carry out such an order unless there were special circumstances or public interest was directly involved.
So was there a
They
public
denied-
interest?
Yeah,
Public interest involved in updating a privately owned steel plant?
no. Yeah, there was.
No, there was not. Now, how many of you remember back, it was a year or two ago, where there was a bridge over on I-75 or I-85 over in Atlanta that collapsed? Remember that? Is that a public interest to get that repaired? Oh, absolutely. It crippled Atlanta's rush hour, didn't it? Just like Birmingham's traffic's about to be crippled. Do you think a court would get involved in the supervision of those? It's not involved yet.
If they don't build it within a certain amount of time, I imagine they probably will be.
Well, the contract here, just like the contract over in Atlanta, involved incentives and disincentives. According to the article I read, AL.com, they've got a definite repair date 14 months from now to have everything finished on 2059 downtown. For every day that they finish early, they get $250,000. They did the exact same thing in Atlanta, didn't they? And for every day that they're late, they have to pay $250,000. Now, how much is it going to cost you to hire 10 extra people for, I don't know, a year? Hold on. 10 extra people, $25,000 a year. That's $250,000, right? I'm just doing it for easy numbers. And if you hire those 10 extra people for the year, you can get done 2 months early.
Yeah, that's...
And their cousins.
So you're spending $250,000 to earn how much?
15 million?
30 times, or 60 times $250,000? That's the same situation as was involved here. They were wanting this company to hire additional workers to get the work done quicker. However, did the fact pattern disclose any financial incentives to get it done? The problem is the contractor had a certain amount of fixed cost that they did not want to go above because that would affect what? The bottom line or their profit margin. Now, the way to cure that bottom line or profit margin problem is to put the incentives in the contract. You get done early, you get a nice incentive. You get done late, you have to pay that as a disincentive. How many of you want to bet that that project's done faster than 14 months?
I have a question though.
I think 440 is always going to be messed up.
Professor, I have a question.
Yes.
So, let's say that happens. And remember in Florida, there was that pedestrian bridge that collapsed. They put it up over the weekend.
Central Florida, wasn't it?
Yeah, so I'm wondering if there's an incentive built in and you meet that incentive, but yet there's something that happens, a disaster, will that company that put the incentive in also be held liable in a lawsuit?
Well, they're going to be sued. We know that, right? Because anybody can be sued for anything.
Right.
Are they going to be held liable if they can show that they were negligent in building that they took any shortcuts or didn't?
And they took shortcuts because they had a financial incentive to do that from the parent company, whoever awarded the contract. That's what I'm talking about. The company who awarded the contract. Well, they have.
So how do you protect the public against something like that?
It's always called public policy.
Well, what I'm getting at is most state agencies that contract require a vendor or a manufacturer to have a performance bond.
Right.
So if in the contract they require them to have insurance, then
Okay.
Are there not inspectors that throughout the process have to sign off on
in theory. All right, Walgreen Company versus Sarah Creek. Mr. Cruz.
Yes, Walgreens leased a building for their store there, their pharmacy from Sarah Creek in Milwaukee. They had a clause in their contract that said that the mall would not lease to any other pharmacies. One of the key stores moved out of the mall, and Sarah Creek leased to this new store, which I don't believe they mentioned. If I did, I missed it. And then it said that they had a pharmacy in that store. So they filed an injunction, and basically what they said at the end is, yes, the court granted the injunction till the end of the lease, so they wouldn't infringe, because it'd be hard to look at all the evidence and calculate how much damages and stuff like that.
That's right. The damages would be impossible to calculate, and it would involve speculation, so they said it's easier to grant the injunction till the end of their lease.
Yes.
Which is the only time that they're guaranteed to be exclusive, right? All right, specific performance efficiency and the Coase theorem. On 639, that explains the Coase theorem in that first full paragraph, starting with "but if we assume." So the Coase theorem states that when a transaction costs are absent or sufficiently small, the legal entitlements well defined, parties will bargain to an allocatively efficient outcome under any remedy. There's your theory for this week. Now let's get to section 2, measuring expectation. This actually gets back to the very first reading assignment and all the measurement of damages that we talked about before we even knew what a contract was. Now it actually starts explaining it the way you ought to have, the way you understand it. Your expectation interest is actually the measure of damage that is preferred. The last sentence says, the promise then said to have received the benefit of the bargain or to have been made whole. That's what contract breaches are all about. Give them the benefit of their bargain and make them whole. Look at restatement 347 on the top of 641. It gives you 3 parts to it. They also talk about market value on 640. The market value before and the market value after is another measure of damages. That's an alternate one. The real key to it, though, is 347 with those factors. And then what I've got really highlighted is at the bottom of 641, that is your measure of damages. The loss in value plus any other loss minus the cost and loss avoided. That's what the measure of damages is. So if you had a fact pattern that says, by breaching this contract, they saved themselves this much money that they would have expended to complete the contract, but now the property is worth less, $10,000 less than it was before. Well, what is it? The loss in value, $10,000 is the loss in value, what it was before. They saved this much money by not finishing the contract, that's the cost avoided. Can you not figure out the damages from that? If there were no other loss in this case? Absolutely, you got a dollar value. So that's how you come up with the dollar value for your damages.
Could you define what a thick market is? That was written through there. And
A thick market and a thin market. A thick market is where you have a lot of competitors, and a thin market is where you have a monopoly or an oligopoly, where there's very few competing. So your prices are going to be pretty fixed if it's a monopoly, because you got one person saying what the cost is going to be. An oligopoly, where it's several in charge, not just one, but several, a handful of them, then their prices are pretty much going to be fixed the same way as a monopoly. There's not going to be a lot of competition. But where you have everybody out there doing something, then the market's going to adjust and you're going to find somebody who's going to do something for a reasonable price. That's thick markets. It comes along with the assumption that there's going to be more cost competition. You remember the old supply and demand? That's all it is. Incidental losses on 642 include costs incurred in a reasonable effort, whether successful or not, to avoid loss, as where property pays brokerage fees or arranging to attempt a substitute transaction. So restatement 347 is highlighted. Incidental is one of your other losses. Typically for a seller of goods, the cost of halting delivery and transporting the goods and caring for the goods after the breach by the recipient. All right, if you, hypothetically, if you have put a check in the mail to pay for something that you bought, and you find out that, whoops, it broke and it's supposed to be good for 5 years and it broke the day you tried to use it, what is the remedy that you have? Cancel the check or put a stop payment on it, right? So what would one of the losses be that you've incurred?
The fee.
The fee to stop the payment, right? That's an example of one of those other losses to stop the transaction. All right, now they introduce you to fixed and variable costs. How many of y'all took economics in college? How about accounting? Y'all know what fixed and variable costs are, right? Is there anybody who doesn't know what fixed costs are? Good, we can skip that. Variable costs? All right, Vitex Manufacturing versus Caravex. Mr. Davidson.
Vitex and Caravex, contract, material, Caravex recent contract, supply Vitex, Vitex sued to recover for lost profits. They sued to recover lost profits. And the trial court found that Vitex's profits for processing the wool material would have been $31,250. And that its cost would have been $10,136. Vitex damages for lost profits were set at $21,114, and Caravex appealed, claiming that the trial court erred and basically they disregarded Vitex's overhead, the fixed costs. That basically continuous expenses of the business, like employee salaries, purchasing chemicals, and things like that, when they were determining the cost, or when they were determining the profits, the lost profits.
Okay, one of the fascinating things I found about this is it's actually U.S. Virgin Islands, out in the middle of the Atlantic, or part of it. By the way, we're under a tornado warning till 11:30. But the weather looks like it's north of Birmingham. I'll try to keep an eye on it.
So if there is a concern to go off, where do we go?
Hallway on the first floor where there's not any windows. Yeah, stairwell's another safe place. All right, notice also that the U.S. Virgin Islands, their legislature has imposed quotas on person engaging in processing and limiting their output. So really the manufacturer in this case can do work, but they can't do too much work. And they did not allow the overhead, because in theory the overhead was included in whatever their profit calculation was. So they specifically disregarded the overhead. Restatement of Contracts, section 329 at the bottom of 644. The notes on 646. Note number 1 gives you your damage equation all over again. They've actually put this thing in the book twice. I've not seen it. Yeah, it must be important because I've not seen anything else in this book put twice except maybe a case or two. Profit is the difference between revenues earned and all expenditures required to generate that revenue. Fixed and non-fixed costs. And then you've got marginal revenue and marginal costs. Marginal is the added expense to make more versus the added revenue. Marginal revenue is what you make from the additional once you've got all your overhead paid for. Sunk costs. Those that cannot be avoided or recouped once they've been made. Anybody want to get an example of what a sunk cost is?
Like an event that was missed or something?
Well, on 647 they talk about leasing a fleet of trucks. Once your fleet of trucks is leased, you're under a contract to pay for those trucks, period, regardless of whether or not you use them. Can you get that money back? No, so you better put them to use, right? Yeah, deposits for wedding vendors if they're non-refundable. That's a sunk cost. Laredo hides. Mr. Dixon.
Yes, sir. This was a case where we had a little hides had purchased, Mr. Bodie purchased cattle hides from H&H Meat Crops Company, a company out of Texas. H&H basically purchased cattle hides, provided cattle hides to Laredo hides, in which it planned to ship to Mexico under the assumption that they would have a long-standing contract for those hides. The Laredo hides mailed, after receiving two shipments, they mailed a $9,000 check to H&H, in which within that process the check was delayed, so H&H demanded from Laredo hides to give them an ultimatum that if the payment wasn't made, that they would cancel the contract. And so they did so in delay of that check being received. And then, of course, Laredo hides brought suit against them for a breach of contract. And the court found in favor, was ruled in favor of the actual defendant. Initially, they ruled in the favor of the defendant. And then, of course, the upper court reversed and limited the decision for the Laredo hides.
That there was a breach and they were entitled to be compensated. Okay. Look at note number 2 down at the bottom of 649. A different measure of damages. Now, this one's an important one. If somebody breaches by not supplying you with goods, and you can go and get the goods somewhere else, even though it's a higher price, you can sue them for the difference in what your contract was versus what you had to pay to get the replacement. That's substitute transaction goods. The injured party arranges a substitute transaction and claims the damages based on that transaction rather than the one the damages formula set out earlier. That is an accepted alternative, is whatever the cost for you to replace the items. Now, what does that mean? Well, if you hire a plumber to come to your house and they stop in the middle of it and they're going to repair your dishwasher for $100, but you got to get another one to come in to finish what this one started and it costs $250, you can sue the first plumber for the $150 difference because you are entitled to get the benefit of your bargain, to have it done for the $100 rather than the $250 you ended up paying. Yes, ma'am.
Is this case one of those where the packer was the cost of hides had gone up so significantly that it looked to me as though the packer selling at the current market price would make a lot more money even paying the difference to this company when they had to go out and get additional hides to fill their tannery order. So
Unless they were-
it's an intentional.
You remember the section in our reading last semester about the economics of breach?
Right, that's what I was thinking about. Was this an intentional economic breach?
Looked like it, didn't it?
The math, my math, which is not great, looked like they were going to make a lot more money doing that than adhering to the contract.
One of the things that you're going to notice as you start going through law school, and you're going to see this in a whole lot of classes, an underlying pattern, is that most decisions in the law are based on cost-benefit analysis. And in here, in this decision, it would cost them less to breach and pay the difference than it would for them to actually perform the rest of the work.
Which is an affirmative breach, right?
That's an affirmative breach from last semester. On the top of 650, we've got UCC 712, 2-712 and 2-713, which deal with substitute purchases. Substitute transaction for services. Note number 3, if an employee is fired in breach of a contract and does other work as a result of being freed from that contract, the employee's damages are based on the salary that would have been earned under the broken contract, less what they earned by doing other work. And since we're talking about football, I put a note in here in my book about football coaches.
That's exactly what I thought about.
How many of you know who Les Miles is? He was fired from LSU, wasn't he? Did he have incentive to go to work? No, he still had, LSU had to pay him out, right? And then if he had gone to work somewhere else, then LSU would have been entitled to what's called an offset. Whatever he earned, less than what they had a contract to pay him, they only had to pay him the difference. That technically is called an offset. That's what we're looking at here.
That's not a responsibility though to mitigate damages.
Oh, I can mail out resume a week.
As your agent put out, who's looking, who wants to get back in the game, let them talk about it on fine bonds.
Instead of making Dr. Pepper commercials.
Yeah. Yeah, I wonder where it was on top of the building. Did you see the file?
How does that work for endorsements? You mentioned Dr. Pepper commercials. If he's got he's coached at LSU, he has a contract with Dr. Pepper, and he gets fired, and if he keeps his endorsement deal, does that go against that contract at all, or is that a completely different issue? I would imagine, but I wasn't sure.
I think that's separate.
Okay.
Because it was separate. He was getting that in addition to his salary.
Okay.
Collateral source rule came up again on page 650. Rule prevails in some states. An employee's recovery in tort is reduced by the sums received from a collateral source, such as unemployment compensation and similar benefits, in order to avoid double recovery. What they're talking about there is that if you get involved in a car wreck and you have to take work time loss, and your employer says, well, if you can't come to work, I'm just going to lay you off. So you go and get your unemployment. Well, the person that ran into you is entitled to an offset or credit for the monies that you receive for unemployment, because technically it's not work time loss. It's monies that you received for your related to employment or unemployment as it is.
People in Alabama that have been furloughed, I've heard that some of them, or all of them, I'm not sure, are able to get unemployment. Would that be considered an offset, or will?
They're not going to be able to sue the federal government.
So it will or won't be an offset?
Well, if they can pay their bills and keep from having a mortgage foreclosure, that's a good thing. But technically, are they earning any money right now? So if they go back to work tomorrow and they only get paid for when they work, then they're missing the whole month worth of salary. Federal government doesn't have to pay people not to work.
I thought that the federal government said that they were going to pay for furloughed people.
How many of you would like free government money? Would you like to be paid not to work? What does that what does that do to the people who are actually working?
Higher burden on them.
I'm just trying to figure out how this shakes out for people that
Now, if they do put the unemployment to the government, and like I said, well, you got unemployment, I'm gonna take the money that we're gonna pay you
out of your
anyhow.
back pay, they're supposed to be giving back to
Well, let me tell you one example that I do know is when you have a job and you get summoned to come to jury duty, and your employer decides to go ahead and pay you for not coming to work, but for serving on jury duty, they're entitled to ask you to give them the money that the county gives you for your jury duty service.
Really?
They are entitled to ask for it. Now, do they always? No.
You said no.
They are entitled to ask for it if they pay your salary for that time. That's kind of another collateral source, I guess. All right, and the last thing I've got in my notes is 651, the alternative product rule. It's, just read it. I mean, you've got substitute products and then you've got alternative products, which are not the exact same. That's what you need to know about it. Now, anybody else come in after I called roll? Come see me so I can make sure you get on the roll.